I've been looking through the pictures, and I see you there. Were you the one leading your team there?
No, I had the opportunity on invitation by Bob to go and give some insights when they were reviewing, when they were treating the judicial,
right?
The theme that borders on the judiciary.
Okay.
And then subsequently, I was also part of our team, our caucus, the team our caucus selected to also engage them. I must put it on record, our caucus, our party has since put together a committee, which I'm also part.
Inusa mentioned that.
Yeah. And whatever I'm going to say here is not, representational of what the committee is doing. It's my personal view. It may be moderated subsequently by engagement at that level. So I wanted to put it on record.
That's fair.
Even before the MPP came to office, I'd spoken to Prof, if Prof recalls. I thought that there was a need for constitutional review. But I'm a bit conservative, and my views are quite moderated, if I would say by experience and some interactions that I've had in the system. I am of the personal view that a constitution is a legal framework which must be grown through judicial interpretation and legislation. And amendment should be sparingly done. And so if there's going to be an amendment, it must have been occasioned by a major event. And indeed, when you look at Professor Fiaju's report, he makes mention of that. He acknowledges it and says that the invitation that had been given to them to undertake their exercise shows the extent of maturity that we have achieved as a country, more of a housekeeping exercise. And so, yes, I am of that school of thought. I'm open, however, to accept where there is a compelling argument that beyond our experiences in the last 30 years, there's some provision of the Constitution that must be touched. And, that must be very compelling. For one reason, this is the longest constitution, 7 constitution we have had. It has survived about 4 transitions. And so, as the Americans would say, if it hasn't broken, you don't fix it. And so, whatever we intend to fix must have been broken. Whatever we intend to fix, there must be a compelling evidence that as we go forward as a country, we are likely to have a problem. Look, the Americans have had their constitution since 1779. It was, put together in 1777, promulgated, ratified 1778. The British have had an unwritten constitution that they've practiced for several years, right? Until Magna Carta, there hadn't been a major event necessitating reforms. Subsequently, we have seen certain reforms. For instance, the British now has a Supreme Court, right? Contrary to what prevailed historically when they used to have the House of Lords, okay? Subsequently, there has been the Constitutional Reform Act, yes, that has also now brought together the entirety of the realm under one Supreme Court, right, chaired by a president, unlike here where you have a Chief Justice that presides over the entirety of the judiciary. And you see that anytime there is the need for a constitutional intervention, it should be a major event. That really shows how sacred the Constitution is, so that nobody can just tamper with the Constitution. And so that for me is very key. When I look at Professor Prempe's commission, and I need to commend them, they've done a very good job. I appeared before them, sitting through the process, watching them listen to everybody, trying to make sense about, of what everyone is saying is very difficult. And so it's a very huge public service they've delivered, and they deserve the commendation. The challenge is that what they have out, unlike the Professor Fiajo Committee's report, doesn't have the contextual information background. And so you don't know what informed a particular proposition as compared to Professor Fiajo. And so it becomes very difficult. And that for me is very, very important, because when you look at, for instance, Section 10 of the Interpretation Act, that informs interpretation of the Constitution. And that is why historical perspective or events informing a constitutional reform is very important, so that there is that sentimental attachment, right? And so that for me is key. And we hope to see that. Once we see that, I believe that we'll be able to have more informed discussion than we are having now. But what we have now is very difficult to have that informed discussion. What we have now, to be able to give an informed analysis of it, you have to do a comparative analysis between what they have given us and the Professor Fiajo Committee's report and raise questions. For instance, when you look at the Professor Fiajo Commission's report on the age, on the tenure of the president, they did a historical analysis,
right,
of where the 4 years came from. The fact that the Consultative Assembly preferred 5 years, but the powers of the government committee, right, wanted the Commission of Experts wanted 4 years. The powers of government committee wanted 5 years, but upon a careful evaluation, they decided on the 5 years. The fundamental question, 4 years. The fundamental question is, what mischief are we seeking to cure with that extension or proposed extension? The mischief, for me, very respectfully, I got that from Professor Prempe's engagement with Kweku Asante, which is about giving the president sufficient time to finish with his work. Brilliant. But we have to appreciate practically that no president will be able to finish almost everything he finishes, he constants. And so the issue really has to do with continuity. And so we have to pass a law to ensure continuity and not rather extend the president's term. Because the president, he will take loans, he will not be able to finish the loans he takes before he leaves office. He will start projects. The project's lifespan will exceed his tenure. He will pass laws. The laws will exceed his tenure. He might not be able to implement them. And so realistically, adding 1 more year will not enable the president to finish everything he starts. And so it is an issue of continuity. That has been the debate. Successive presidents not being able to finish projects that their predecessors started. I think that we should look at how best we are going to do it. Professor Prempe's committee did something that for me was very, very brilliant. You see, when you look at Professor Fiajo's committee's report, it talked about strengthening the National Development Planning Committee. Professor Prempe's committee takes it further by saying that every bill that comes to Parliament must show how it ties into the National Development Planning Committee. It is like what we say in civil litigation, the overriding guidance. That for me is very important, because that way Parliament will now have the opportunity to assess whether what is being brought before it ties into a national development project. And so that would then render the 5-year or the extension by 1 year redundant. It makes it unnecessary, because then whatever the president has started, somebody will take it from there and complete it. I believe that we must, because the Constitution is a legal framework that is capable of growth, as Justice Sowa said in to 4 versus Attorney General, we must explore how to grow the Constitution through legislation and through judicial interpretation.
Right.
That calls for a stronger intellectual-based judiciary. If you compare, if you are going to be very honest with ourselves, if we compare the pre-2000 judiciary to what we have today, and sometimes we all say it in our closet, it's not the same. Why is it not the same? It's not the same because of the mode of appointment. The mode of appointment has resulted in patronage. When I look at Professor Prempe Committee's report, it looks like they want to work on the mode of appointment, but I don't think that It is informed by practical experience on the ground. Why do I say so? They hand it over primarily to the Judicial Council. Without, and I stand to be corrected, I've gone through your report, I don't see much work being done on the current Judicial Council. It looks as though it's been left the way it is. I can understand why they did that, because you see, when you look at Professor Fiaju's committee's report, when they presented it to the president and proposed tinkering with the current composition of the Judicial Council, the white paper rejected it. And so I can understand where they are coming from. But if you don't tinker with the current Judicial Council, it is much ado about nothing. It is as though you have handed over the judiciary to itself and the executive, right? But the compromise of the judicial independence of this country is internal and external. You have somebody sitting at the Supreme Court speaking to somebody at the High Court. You have somebody sitting at the presidency speaking to a judge. You see, when you have a Judicial Council that will now decide on appointments to the High Court, decide on the appointments to the Court of Appeal, and decide on the appointments of the Supreme Court, and you have a senior member sitting on the Judicial Committee and telling you, a High Court judge, what to do for him, you will do it. Because you know that your promotion is in his hands, just as the executive. And so that portion of the commission's proposal, very respectfully, sends us back. In fact, but let me wrap up. When you look at the Commonwealth, when you look at what is evolving in the common law jurisdiction, take Canada, take even the United Kingdom, right? They set up a search committee, which is the equivalent of what the University Council does when they are looking for a vice chancellor. They set up in Kenya, Prof's favorite jurisdiction. They set up a search committee, and that search committee will interview applicants, scrutinize them, and decide who is fitting for the job. And so that current proposal doesn't solve the problem we face.
Right. Thank you very much.